Hello, everyone. I'm Jason Montgomery, partner in Husch Blackwell's Higher Education Group. Thank you for joining our program today. Before we begin, I would like to cover a few housekeeping items. At the top of your audience console, there are multiple applications for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the Program Materials folder. Auto-generated closed captions are available for today's program. To turn on closed captions, click the CC button on the bottom right-hand corner of the media player box. This program has been approved for legal education hours. For live attendees, hours by clicking on the Continuing Education sign-in link at the top of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with the recording of the webcast for watching and sharing. That is all for housekeeping items. Let's get started with our program. Joining me today is Christina Miner with Husch Blackwell and Billy Ebel with Husch Blackwell Consulting. Christina is a senior athletic consultant in our higher education group. Before coming to Husch Blackwell, she attended Marquette University's Law School's sports law program, interned with the NCAA, and accepted a position after graduation in compliance for the Big Ten Conference. She later joined the compliance offices of Rutgers University Athletics and Northwestern University. Now she assists clients with athletic compliance reviews, NCAA infractions, student athlete eligibility, Title IX questions, and athletics regulatory issues. After 14 years at colleges and universities, Billy joined Husch Blackwell Consulting in 2025. In the midst of the rapidly changing landscape for collegiate athletics. As an athletics consultant, he works with schools of all sizes. He assists clients with matters such as athletics compliance reviews, NCAA infractions, student-athlete relations, Title IX questions, and name, image, and likeness rules. Much of Billy's current consulting work centers on the House settlement as he advises institutions considering whether to opt in. Billy has devoted his career to college sports, serving as a former Division I college coach and recruiter at both public and private universities. And he's also seen firsthand the impact of athletics participation on students. Okay, I think I need to have you guys help me with my bio because I think you guys are better. Welcome, everyone. We have a packed agenda. Hopefully, we're able to give you some good information today. The Star Wars reference is mine. It is the Empire being referred to as the NCAA, and they're striking back against, I guess, chaos in the athletics industry. Really what we're seeing here and what we'll talk about today is the NCAA and the Power Four conferences attempt to address NIL deregulation and booster involvement in college sports, along with attempting to limit liability in antitrust proceedings. So we're going to talk today about the Division I post-House settlement world, new Division I rules, NCAA enforcement, and the CSC, the Collegiate Sports Commission, the new enforcement arm that of the Power Four that is being used as part of the House settlement implementation. We'll talk about federal intervention, the Trump executive order, congressional bills that are out there, including the SCORE Act, which is the one that's been highly publicized and may actually make it to a vote. We'll also talk about ongoing lawsuits and finally end with the NCAA sports wagering policy. So to start off, the House settlement recap is, as most of you know, the total of back damages is approximately $2.8 billion. The amount of 22% of the average shared revenue, that's what the pool will be, and it's currently $20.5 million. But I want to dive a little bit deeper and talk about what the House settlement really does for colleges and universities in Division I. First and foremost, the settlement numbers in part are based on calculations related to the television broadcast rights of men's basketball and football athletes primarily. And there is, while the back damages use that calculation, include those numbers in that calculation. There's no agreement moving forward that athletes are permitted to share in television rights. That's a significant win for the NCAA, and I think stabilizes at least that area for a certain amount of time. There is a one case out there that was Marshall versus ESPN in the Sixth Circuit. That was back in 2016, before really we saw this NIL movement that essentially indicated that athletes don't have a property interest in their names, image, and likeness when they appear on television broadcast games. I think that obviously the times have changed, precedent has changed, and depending on what jurisdiction you're in, I think the NCAA and the Power Four conferences made a calculation that, in fact, that was subject to additional analysis by the court, and therefore settled the House lawsuit. But as part of that settlement, did not agree moving forward that there were any rights that athletes had in broadcast. The settlement also set roster limits, as you all know, that Christina will talk about here shortly, versus scholarship limits. And that was a way to, again, in the course of this settlement, limit some additional antitrust liability that was out there based upon the scholarship limits that existed in Division I. The settlement, as most of you know, also allows for direct payments from institutions, and those have primarily been made in the form of NIL agreements with athletes. The injunction creates a cap on payments moving forward and allows for regulation of third-party payments, which is what the NCAA and Power Four conferences are attempting to implement as we speak. One other, I guess, a couple other points to be aware of. There are still pending appeals on the House settlement. There's 7 appeals, mostly related to damage calculation, but also related to Title IX. What this settlement did not do, I just talked about the good things that it did do for Division I and for the NCAA. What it did not do was address any issues related to employment, Title IX, state NIL laws, and really the overall ecosystem of the NCAA and governance of the NCAA and Division I college sports. What I think is important to track at home is, this injunctive settlement agreement is set to be in place for 10 years, and we'll talk a little bit more about the provisions of that settlement, injunctive settlement agreement. But really, I think we're looking at a limited time frame here within which this system may actually function, in part because television rights for the men's basketball tournament and the college football playoff will be up again in 2032. And just a reminder of the amount of money that's involved here. Men's basketball had an 8-year extension on a previous contract for $8.8 billion. So that's $1.1 billion a year for men's basketball tournament alone. The college football playoff just recently finalized their television agreement with ESPN, and that's a $7.8 billion 6-year agreement. So $1.3 billion, a year. And why I'm bringing this up is because all of this settlement and the regulation that we're talking about revolves around maintaining the status quo for a time period within which the television and sharing of revenue is limited in some respects. And I don't know how long realistically that can continue to go on. But a couple of other things to recognize: the men's basketball NCAA tournament, the $1.1 billion is shared amongst all Division I member schools equally. Well, equally, it's shared based upon shares in that tournament, and also based upon agreements that Division II and Division III will be funded from that money. The $1.3 billion college football playoff amount is only shared with those football playing schools, and in particular the Power Four conferences have the vast majority of that money. So that being said, I'll turn it over to Christina to get into the details of the House settlement.
All right, thanks, Jason, and thanks everyone for being here. I'm going to go through some of these slides fairly quickly. Most of this stuff is probably some topics that you all are already aware of. This chart, for example, I think it's buried somewhere in one of the hundreds of pages of guidance related to House on the CSC website, but we'd like to be efficient here. So again, I'm not going to go through the entire thing, but just a few key points. The one being the pool cap is not the same as real dollars. So that's something to keep in mind from a budget planning, strategic planning standpoint, conversations with stakeholders, et cetera, particularly as you look at scholarships and Alston awards and things that fall under those two buckets. They count up to 2.5. So when you're seeing X school is spending $30-40 million, that's probably has something to do with it. Other key point, I think the devil's going to be in the details here, particularly with regard to third parties. I know a lot of our institutions have a handful of individuals that are kind of borderline where they wear multiple non-institutional and institutional hats. So I would say, that needs to be monitored and educated on your respective campuses. And lastly, it's not really in the chart, but student athletes do have to meet progress towards degree benchmarks in order to be eligible to receive these payments. So for my academic and collegiate model purists, there is still some hope. But at the same time, we'll see how that goes, depending on how many of these agreements, are front-loaded, or the timing of the individual, periodic payments kind of line up with PTD certification or not. But the information is there. Moving right along, Jason already talked a little bit about the roster limits. Ooh. Oh, sorry, that was me. I was clicking. My bad. And so again, not going to go into super in-depth here, but the roster limits for those that are either your Power 4, Power 5, or have opted in, they're now in Bylaw 17. For those that want to flip through the 300-page book, they're no longer in Bylaw 15. If you didn't opt in, the 24-25 scholarship limits are still in the 24-25 manual. That is posted and linked on the CSC website as well. Just a quick note with respect to designated student athletes. Now, while they do keep that status as a DSA for their entire career, regardless of whether they transfer or not, that status only applies to those that were designated as such before this current academic year. So if an institution opts in next year, they don't get to designate designated student athletes moving forward. So just a quick point there. From what we've seen, that was a small point of confusion early on.
And Christina, just to be clear, if a designated student athlete, so this is someone who was on a Division I team's roster during the 24-25 academic year and then was told they weren't going to be on in the 25-26 year as a result of roster limitations. Is that generally accurate?
Yep. As always, Jason, you're on point.
And if they go to another school, does that school have to count that athlete against their roster limits?
Nope. So this is incredibly student athlete friendly. So the whole idea of this, this was like one of the last pieces in the actual settlement process. A number of student athletes in that final hearing objected about, whether it was walk-ons or just individual student athletes that had been told whether they had signed and said, no, we, not signed, but had committed and said, we don't have a place for you. Recruits, same thing. So this was really a compromise to kind of get over the finish line. So yeah, no, it's very student athlete friendly. I don't want to say too much like, yay, everyone transfer, but that's how that would play out.
And but the money that if those athletes received any money, that would count against, and if they received NIL money or something.
Mm-hmm, yeah, so this is just about the roster limits themselves. So they don't count, but then the dollars are something else.
And then one other big picture reminder out here for everyone is this, roster limits and what we're talking about each institution has to evaluate their Title IX compliance separately, and roster limits, regardless, won't be able to be used as a factor in arguing if you have disproportionate or participation numbers and/or scholarship allocation. And I won't get into the sticky wicket of what's a scholarship and what isn't a scholarship, but suffice it to say, there is an argument that, and I'll talk about a little later, that any financial assistance from an institution should be provided proportionally to men and women, and that in an argument on the opposite side that NIL payments are separate from financial assistance and should not count toward a Title IX analysis for purposes of proportionality. Now, just to baseline all of this, NIL payments, and we jumped right into it, but really institutions are only into agreements for athletes' name, image, and likeness, publicity rights, and there is some component of those rights that are intertwined inextricably with the athletics performance and abilities of the individual. However, per this settlement and consistent with current NCAA rules and CSC guidelines, this is not actually pay for play. This is a purchase of rights and additional benefits that can be provided to athletes up to the cap amount. In fact, you don't have to provide athletes with additional money in the form of NIL. That is, simply a mechanism that most institutions are using. Now, practically, I don't see personally any distinction between what's occurring currently in the environment and pay for play, but we'll leave that to others to make a determination as to where that line actually is.
Thanks, Jason. No, I look forward to finding out what that line is, along with hundreds of membership institutions. Also, tied to the settlement, but not necessarily in the settlement itself, there's quite a long list of additional Division I NIL related rules. Again, there's hundreds of bylaws. A lot of these, if you really want to look at the change, you'll have to go to the proposal, because things have been deregulated and eliminated, so you won't find it in the manual itself, but here we are. And so a lot of these changes were done to align with the House settlement, but as I said, not necessarily part of the settlement itself. And just an important note, as you're bringing on new student athletes, coaches, staff, or just educating the veteran members that you have, some of these rules apply only to those who opt in, and others apply to all of Division I, like NIL disclosures, which we'll talk about a little bit later. So this is absolutely not an exhaustive list by any stretch of the imagination, but just a few highlights. In addition to, yes, that you've got the NIL compensation from third parties, subject to approval by CSC. And as I mentioned, the disclosures of all NIL agreements at $600 or more are that need to be disclosed through NIL Go, and we'll talk about that later as well. NIL recruiting conversations is an interesting change that for some have gone under the radar and others have taken full advantage of. So prospects and transfer student athletes may discuss, negotiate, or enter into NIL contracts with third parties, and the recruiting rules related to who's a permissible recruiter and who can initiate phone calls with prospective student athletes and the like, those have been deregulated. So technically, boosters can have phone calls and correspondence with prospective student athletes and transfers as long as it relates to NIL discussions or negotiations. Supposed to be still subject to other recruiting rules, but the way that the legislation is written, I'm anticipating a long list of interpretations and education columns to dig further into that. A couple other points. As I mentioned, institutions can offer NIL agreements prior to enrollment, which is interesting because the bylaw that says you can't have a written offer of aid prior to August 1 of a prospect's senior year may or may not align with the discussions and correspondence related to NIL. So we'll see how that plays out probably shortly here as the fall seasons continue. Personal take, as I mentioned, I think we're going to see some amendments, tweaks, emergency legislation, as it were, related to this. There's a lot of holes, I think, that go along with that particular change. Just some miscellaneous deregulation. Amateurism does not exist in the bylaws anymore. It is now collegiate model. There is no longer a counter status because there are no, we don't have limits anymore. So counter status, which means medical non-counters, there's no need for that anymore. And so that all kind of defaults to the former student athlete benefits that arose out of the Alston case, I want to say 2021. In addition, promotional activities legislation is gone. Camps and clinics restrictions have been largely deregulated, as have other bylaws that were kind of tangential to NIL restrictions. So a lot there. I know no one wants to hear this, but the changes to legislation probably do require quite a bit of updating policies, rules education, particularly as it goes out to student athletes and coaches, to my compliance folks. You're going to be fine. It's going to be fine. To everyone else, please ask them. It's a lot. There's a lot of change, especially for those that have been doing this a lot. So everyone's, for better or for worse, a little bit on equal footing as we move forward into the academic year.
So a couple of additional points on that slide, Christina. Just real quick, the NIL conversations piece during recruiting. I don't know how that's ever going to be regulated again or enforced, but that's the result of the Tennessee case and the injunction, and then the agreed upon resolution in that case related to third parties. But it makes everything a little bit more difficult. Big picture here, many NCAA rules did not change. And so you still have recruiting inducement rules that are on the books. You have contact periods, definitions of what a contact is, what an evaluation is. All of those remain the same. So basically, we've doubled the work for folks in athletics compliance in some respects. They have to both be aware of what's going on in the new NIL world and also the old world. Now, the question still remains as to what will be left to enforce. In other words, what is still meaningful? And I think there have been public reports where athletics directors and others, I think, misspoke about exactly what the settlement agreement does. It really only allows for regulation of the NIL space and the cap space. It doesn't really allow for regulation of recruiting and other activities or academics, for example. However, it remains to be seen how intertwined those two activities become, such that there has to be a solution that is only one enforcement entity. And I'll talk about that a little later.
Thanks. All right. As Jason mentioned, just quickly about NIL Go and CAPS. So we'll start with CAPS. So CAPS is managed by LBI, and so that is for institutional monitoring and tracking of the pool cap and direct payments and additional benefits that are going to student athletes. Per usual, you've got comprehensive reports that will have to be submitted. Hopefully at some point there's going to be either some alignment, again, I'm using that word a lot, either some alignment or reduction in how many times institutions have to report the same thing in different formats. So that will all remain to be seen. With respect to NIL Go, so that is managed by Deloitte. And so that is for the student athletes. I think one thing that folks probably weren't tracking on when all of this started, at the end of the summer, was that the student athletes are responsible for their reporting. And this is not something that the institution can do on behalf of the student athletes, which is new. But I think for a lot of compliance folks, there's been a long history of hunting down your student athletes to get them to submit their forms and those kinds of things, which at this point, that's not something that they can do in NIL Go. And we'll talk a little bit, well, Jason will talk more about, kind of how these third-party deals are being evaluated. But so all new third-party deals must be reported within 5 business days of execution. I love the word must. I'm not really sure what is supposed to happen if it's day 6, or what happens when, student athlete didn't report something, and at what point are the institutions, being held accountable for knowing or not knowing. We'll see. So that, should be interesting for all. And then, as I mentioned, the reviewing associated entities and individuals, which we'll talk about a little later. But before I get into the NIL Go eval process, any other thoughts, comments from my Kansas City folks?
Right. No, I just get to jump in on all of Christina's slides. So she doesn't get to prepare in advance for my commentary. So
it's Taronda's role.
You're free to jump in, and God bless her. Taronda is on assignment today and couldn't make it. She's more of my foil, and now it's you, Christina. But I guess one big point, and I will address this here shortly, but associated individuals and associated entities, those are defined in the settlement agreement, and they're basically, hey, boosters or collectives. Like, if we want to just cut to the chase, what we're trying to get here is boosters and collectives, if they're going to provide money to athletes, they're going to have additional criteria to evaluate how that money is being provided and whether it's a legitimate NIL agreement versus pay for play in disguise, so to speak.
All right. So the 3-step evaluation process, as it were, hopefully the institutions that have opted in or not have seen this or heard it. I believe there were a series of onboarding education modules and meetings that went on, I believe, when we were at NACTA over the summer. So hopefully at this point, folks are up to speed, but just in case. So you've got payer association verification. This is what Jason mentioned is the payer an individual and associated individual or entity. And just a little asterisk there, it is in the bylaw that each Division I institution must submit a list of associated entities and individuals to NIL Go. I've already had conversations with several institutions that said that's absolutely not going to fly, because those are more likely than not going to be some of your high-level donors and boosters. And for some institutions, that creates a privacy concern, and others really just don't want to do that. So again, from an enforcement standpoint, which Jason will talk about later, we'll see how that goes and how that is getting enforced. Step 2, valid business purpose verification. This is the thing that has changed very recently, so I won't dig too far into that, but essentially is the baseline is whether the agreement related to promotion or endorsement of goods or services provided to the general public for profit. That created some angst amongst the membership, and certainly amongst a lot of collectives late in the summer. Also, we're still in summer, so I can say that. The final piece is the range of compensation analysis. So when the House settlement was pending, I think we were all talking about fair market value. Fair market value as if it was a single value. Instead, it is a range of compensation. My understanding is that institutions don't know what it is. Third parties don't know what that range is. And so this is, I guess, part and parcel to the reporting and disclosure requirements, but is the compensation at rates comparable to similarly situated individuals with comparable NIL value who aren't prospective or current student athletes at the institution? I have no idea how that was, is actually supposed to be evaluated equitably or across the board. But there's an algorithm that was created to essentially calculate that range of compensation. And so we'll see how that goes. Again, there's a lot of TBD, we'll see how this gets enforced, how it actually applies, versus, kind of what's written in black and white. So if an NIL deal is not cleared, student athletes essentially have 3 options. essentially start over, revise the agreement and resubmit, terminate the deal and refund any money previously received under the agreement, or appeal CSC's decision through neutral arbitration. And consequences do have eligibility. The consequences could be related to eligibility to compete. Again, we'll see. We'll see. I have a hard time believing that we're just going to start sitting student athletes in the middle of their season. We're not really sure like how the arbitration process, the details of that, I don't think are completely vetted at this point. But again, that's another TBD. We'll see. Jason, I know you've got some thoughts about how this is going.
I think that everyone is attempting to recalibrate their expectations with respect to how quickly they're going to get communication back from this NIL Go system, what this clearinghouse really means, and then what the results are going to be. If something's suspended, can we renegotiate that? Is there going to be further action either by plaintiffs' attorneys or attorneys representing a collective or other third party? And in part, I'm going to talk about that here with the next slide. But I think that as I understand it, the modeling continues to evolve in response to plaintiffs' attorneys, and that's the plaintiff's attorney in the House settlement, their concerns about how what was meant by the language that's in the settlement prohibiting compensation from these associated individuals or entities.
All right, well, speaking of evolution, I'll turn it over to you.
Yeah, and just to speak about the enforcement model, so the Collegiate Sports Commission, just again, that's the group. It's separate. It's a separate legal entity from the NCAA, operated by the Power Four conferences. There are at least two publicly identified employees. The person in charge, the executive director, or I think that's his name, is Brian Seeley, a former vice president at Major League Baseball. And there have been others that have been hired. We're uncertain whether there are any investigations or other things that are going on. I guess my understanding is there continues to be some analysis of what the market looks like and what has been submitted in NIL Go by the CSC. And the first part of this, so shortly after, again, the system opened up July 1st. July 10th, we got our first memorandum from the CSC that basically declared here's how we're looking at these regulations, and in particular the settlement agreement. And that regulation is, basically that an entity with a purpose of providing payments to student athletes or an institution could never satisfy the valid business purpose requirement. So essentially, the first out of the box expectation was that no collective could ever pay an athlete a third party agreement. That was met with some significant pushback, both from plaintiffs' attorneys in the House settlement who needed to be part of the regulation process, and also attorneys hired by third-party collectives who threatened litigation against the CSC, the NCAA, and whomever else they could name in a lawsuit, Power Four conferences. And this resulted in a change that the CSC's for-profit inquiry could focus on whether the sale of goods or services is for profit and not whether the entity itself is operating at a profit or loss. And so this leaves you with a situation where it appears that collective agreements will be permissible if you can establish that they are for the sale of goods or services, a legitimate good or service that can be quantified, and the range of compensation is within whatever metric that Deloitte is using. Obviously, continues to be a significant amount of subjectivity in this process, which is concerning for, I think, member institutions and student athletes in understanding what is or is not permissible in this new system. Until we have some public reports about what types of agreements have been approved. I think it's going to be difficult for us to give any reasonable guidance on what's occurring here. It's been clear or made clear by the Power Four conferences, at least one general counsel in that conference, that the Deloitte algorithm and what they're using will not be made public. In other words, they're concerned that if the way that these were being evaluated for purposes of range of compensation was made available, that individuals would attempt to game, quote unquote, game the system. And the reality is, I think it's going to occur anyway. And at this point, it is a determination as to whether you can make a argument whether your entity is selling goods and services, and how much that agreement allows for that with the athlete allows for those services to be provided at. So this gets into NIL deal enforcement. I think what I want to highlight here, in addition to what Christina told us about the actual process. In other words, if you put something in NIL Go, it's not approved, then you can renegotiate the contract and resubmit it, or you can appeal that to a third party. What I think is important to understand is that institutions are not party to that agreement. This is a third party agreement, therefore they're not party to that action. However, as I understand it, they could be brought into that action, at least in a discovery process way. So imagine a situation where your NIL collective is talking directly with your coach, and the coach says, well, we need an extra $10,000 for this kid. Can you get him an agreement for that? And that information is either in text or writing, or maybe not. Maybe it's not in text or writing, but they call on that individual to testify, and or there's some other discovery method that's used to obtain information. That's the scenario where institutions could be pulled into these situations, or scenarios like that. And also, I think it's a question as to what the alternative is for an institution. So if a student athlete has an independent right here, in order to receive this money, what really involvement does the institution have in that process? I guess they could provide legal representation at the institution's expense, although these athletes these deals are making, in some respects, significant amounts of money, where you may get to a point where the services and benefits that have been provided, you're no longer willing to provide any additional payments. I guess a couple other NIL deal enforcement issues that have arisen. One, this concept of prospective student athletes. The injunctive settlement agreement, in fact, does not cover prospective student athletes, and this concept of associated individuals and entities doesn't cover prospective student athletes. There's been some movement to attempt to address this issue legislatively by the NCAA. In other words, requiring prospects to submit the deals that they entered into prior to entering into or agreeing to attend a university. I think that'll likely cause another set of potential litigation issues. Separately, as I mentioned, the NCAA rules related to inducements and others remain on the books. So a question remains whether the NCAA would simply enforce other rules, or whether they could, in an NIL context, against prospective student athletes who were induced, quote unquote, to attend a university by a deal that otherwise wouldn't have passed the NIL Go process. But all of these issues remain in the air until there are some specific regulations written and published by the CSC, and there's an understanding between the CSC and the NCAA as to who is responsible for what. For example, who's responsible for tampering? That's a recruiting issue, but typically if you're being tampered these days, it's with an opportunity to attend and receive a significant sum of money from another institution. That makes it a CSC issue, and we have not yet received any guidance as to how those will be resolved in terms of where the jurisdiction will ultimately lie. So Good news for everyone. You have doubled your liability on a Division I campus. You now have NCAA enforcement and some other group that may come and knock on your door and ask for things. And unfortunately, we're still unclear as to exactly how that will work. Quick poll. Does your institution have a plan regarding if and when NIL Go denies a student athlete NIL's agreement? Just waiting to get a majority of responses here, and then I'll let you all know the outcome. Okay, so most popular response is unclear as to what we're going to do as an institution, but there are some institutions that are planning and some that are clear that we don't yet have an idea of how we will address those issues. Again, there's a multitude of things to be considering as part of this implementation process, and so it's understandable that there continues to be some of these outstanding issues. I'm going to turn it over now to Billy to talk a little bit. Oh, actually, I have one more slide. Sorry, that's good. I jumped the gun. NIL related rules. I wanted to put this in here related to Division II and Division III because there is questions that arise about what can we do in Division II and what can we do in Division III. And the reality is that unlike Division I, there is no institutional NIL agreements that can be made. There's no payments that can be provided directly to athletes. Really, Division II and Division III remain in the same, pretty much the same way they've been since the 2021 deregulation. The one difference I think to understand is that Division II has allowed some more permissible facilitation. Specifically, Division III, I think there's going to be a question related to facilitation and an institutional philosophy. So Division III, you don't provide athletics aid, you can't provide financial aid, and it becomes a little more difficult if there's a Division III collective or booster group that is providing compensation in some way to those athletes. But it's unclear, again, what the enforcement mechanism will be. To be clear, though, the CSC, NIL Go, none of that applies to Division II and Division III. Division II and Division III are still under the good old NCAA enforcement model, and it will be the NCAA that would enforce anything related to recruiting or NIL in that space. Where this becomes an issue that we have noticed, and that I think it's important for those on the call that are at Division II or Division III schools to be aware of, is coaches that transition from Division I, maybe a mid-major or even a significant program, to Division II and Division III, attempting to implement some of the same activities in Division II and Division III that were and currently are permissible in Division I, but they are not permissible in Division II and Division III, and frankly, will be looked at with some significant scrutiny if those coaches are involved in arranging payments or direct activities.
Perfect. Thanks, Jason. So I'm going to just talk briefly just about kind of some post-house recruiting and campus operations. Obviously coming from a coach's background and kind of living firsthand about what coaches were experiencing with all this change in the house settlement, especially on campus. One of the things that I've seen the most benefit on is just the recruiting conversations that are happening, especially now that it's legal for prospective student athletes to discuss and negotiate and enter NIL contracts for commercial NIL opportunities, especially with those third parties. But then also too is giving these institutions a chance to offer NIL agreements prior to enrollment is really changing the way coaches are recruiting. One of the things that we're seeing happening right now is that current student athletes are hiring agents to basically kind of showcase them and kind of have those conversations before kids are entering into the portal. Those are things that have been coming up with just conversations we've had. And then also with the House settlement and NCAA rules, they're going to permit prospective student athletes to kind of have those conversations, especially leading up into being enrolled into the institution. So talking about NIL, obviously deals is driving a lot of transfer decisions. One of the things that we're seeing happening a lot is kind of the positive change that are happening. One of the things I want to talk about is how athletes are kind of enjoying that immediate eligibility upon transfer, eliminating that previous year in residence rule, which I think has turned into a positive for a lot of these student athletes. And then also too, is that these athletes are kind of these deals are giving athletes greater financial leverage when choosing into new schools. So they're kind of looking at different opportunities and they're making these decisions based on what offers they're receiving kind of outside, and leading into the fact that that's why a lot of these student athletes, or the ones that I've heard, are using agents to kind of leverage that before they even jump to the portal, which is causing quite a stir in our world.
Before you transition, one thing I think it's important to note. So we talked about, just to reframe this, house settlement, additional benefits can be provided in any form. Some people talk about these are revenue sharing dollars, but most of the time they're NIL agreements. But there's some sort of contract between the school and the athlete, and those contracts can be for multiple years. But the open question remains whether you can contract to eliminate an athlete from entering into the transfer portal. Theoretically, you can contract for anything, but part of a case that Christina will talk about briefly here shortly, it's Miami, or University of Wisconsin versus the University of Miami related to tampering with a football student athlete, very high profile. Part of the argument for Wisconsin there was that they had entered into a 2-year agreement with the athlete, and therefore they had no obligation to put the athlete in this transfer portal. And once he was not in the transfer portal, Miami had no right or ability to contact him or anyone else on his behalf. So it's an interesting dynamic as to what will occur there. There are some other issues, including jurisdiction, but that will be a case to track on.
For sure. And I think some of the challenges, especially coaches are seeing moving forward, especially with all these changes, is kind of your roster instability. A lot of coaches are having a hard time just retaining their current roster. And now with the accessibility of the transfer, it's just leading more students to look at if they're unhappy or miserable in their current situation, looking outside to see, hey, what other schools can provide this branding potential and financial incentives that is going to benefit me personally. And I think that's why you can see with our graph here is just a record-breaking attendance in the transfer portal. And it's amazing to me that student athletes are jumping in with no prior knowledge of where to go next or what's the next deal coming up. I think that's causing a lot of misinformation, because a lot of these new deals coming through agents is all hearsay with NIL deal rumors, and especially since a lot of this stuff isn't public information, you're just going by hearsay to make your next big jump.
Billy, before we move on, 2 things. One, how many times did you want to sue another coach from another school?
I don't know if I should answer that, but I would say when you're coming down to like the NIL decisions, like it's a matter of a kid might want $10,000 more. And those are the types of decisions that is really tough, because you would think, oh, I'm just going to recruit great kids to come and play for my program. And now I'm having to deal with hundreds of thousands of dollars to make sure that they're happy and they're fitting within the space. But to go back and answer your original question, a decent amount, but I think we'll talk about that on a different webinar.
And then for those folks, we have a lot of general counsel that are on this call, administrators that are going to need to have conversations with their coaches about their NIL process, about their philosophy. What, I guess, is there anything you would recommend to start with, in particular with head or assistant coaches?
I would say currently right now you see a lot of college staffs hiring general managers. So I think right now a lot of staffs and programs are looking, especially at the Division I level, to hire general managers to kind of manage all the contracts, your legal, your financial risk, and then also looking at what tax, liabilities you have or other things kind of coming down the stretch that could benefit your student athletes. So to me, I think the most important question that I would be asking is, what's the pool of money I'm going to have to get the best kids to play for my program? And what type of support am I going to receive? Because I think with just the changing landscape, money is going to talk. And especially if you're trying to compete at the highest level, you want to make sure that your financial is set up to kind of support those athletes that you're wanting to get better within your program.
And what if they say $0, Billy? You get nothing.
Then you just got to move on to the next kid.
Is it fair to say, like you're so you were an assistant volleyball coach, and in your community, which was Power 4, that athletes are expecting at that level receiving something?
I think you're seeing a shift with volleyball specifically. I think we've seen a lot of numbers from basketball and football being kind of the forefront nationally of what you're seeing. I think volleyball is obviously in the up and coming with just the support nationally that we've seen, that I think it could be turning into that direction, especially with the type of athletes choosing volleyball over basketball. You're seeing a lot of shift in kind of what their demands are, but it's hearsay. It's like, oh, well, I'm hearing this person's making this amount of money here. Why can I not make this here? And then that's why they jump into the portal to see what opportunities are out there. But it's hard to go into it blind. And that's when I talked about previously that some of these student athletes are hiring agents to do the work before they even jump into the portal.
Thank you. I got to use you too as an example.
It's
impromptu.
I know.
Appreciate that. Well, as if there wasn't enough going on in NCAA and college sports, President Trump decided to jump in and save it. So we're all very happy that he was willing to do that for us. As many of you know, there on July 24th, the executive branch issued the Saving College Sports executive order. A few just big picture points. Obviously, we have the bullet points on here, but what the executive order did not do. I mean, obviously, executive orders don't have the force or effect of law. They're directing agencies to take certain steps based upon policy that the executive branch is articulating. Now, this executive branch has been more likely to take specific actions at the direction of the policy that the administration is putting forward. And so, this can't be taken with a grain of salt. We have to ensure we understand what is being articulated within this executive order. I think from a big picture standpoint, most of the order aligned with the NCAA's, and whether that's all colleges and universities, I don't know, but at least the NCAA and Power 4 conferences policy positions on various activities. What the order doesn't address, it does not address anything related to international student athletes and their ability to receive NIL payments, either directly from an institution or from a third party. And the executive order doesn't supersede state NIL laws, many of which contradict terms of the settlement agreement and NCAA bylaws that are currently in place. I guess probably two important takeaways from this executive order. One, it discussed the fact that it wanted to limit the number of scholarships and other money that was taken away from women's sports and Olympic sports. And so in attempting to do that, it articulated basically a metric. If a school makes above 125 million in revenue, they should have scholarships at increase their number of scholarships up to the roster limits that have been articulated in the House settlement is the idea. If a school is at 50 million or up to 50 and 125, they should have at least as many scholarships as they did pre-House settlement. And if a school has below 50 million in revenue, they shouldn't disproportionately reduce scholarship money between men and women. The order called upon the ed to enforce the order. Obviously, that could be more difficult if there's no Department of Education, but for now, it still exists and was given 30 days to come up with a plan to address this particular issue. It left undecided and unarticulated what additional NIL payments, how those would be categorized. So as many of you know, there was a Biden administration memo that suggested that all payments from an institution were financial assistance that should be proportionally provided. That was rescinded under the Trump administration, and it suggested there could be NIL payments that were not subject to that analysis, that were subject to an evaluation of whether the market-based, some type of market-based evaluation. With respect to anything, I think regardless of the method the institution is using, it needs to document what its decision is in that regard and what the payments provided to athletes are based upon in some respect, in order to have some demonstration of methodology that they can adequately present if questioned. The other, I think, important piece in the executive order related to the NLRB and the Secretary of Labor, a direction to clarify student athlete status. It doesn't specifically say that it should clarify that student athletes are not employees, but I think based upon the rescission of the NLRB General Counsel's memo that suggested that college athletes could be employees in certain circumstances, the direction would be some directive from the Secretary of Labor and the NLRB that athletes are not employee, under their regulations are not employees. That obviously would not affect current litigation, state or otherwise, that whether that argues that athletes should be employees. In particular, there's a case in the Third Circuit in Pennsylvania that argues that FLSA, Fair Labor Standards Act, should apply to student athletes because they are employees, and articulates a test that's currently still being litigated. But whatever happens here would only be used as support potentially in that case, or a defense in that case, but not definitive. Moving on, I'll turn it back over to Christina.
All right, thank you. It looks like we've got about 2, maybe 3 minutes left. So again, I'm going to go through this fairly quickly. Just kind of here are the congressional bills that we have, and we'll dig into the SCORE Act in just a minute here. We're not quite at the 2023-24 level of, I think there were like 5 or 6 different bills, but there are a number of bills that are being discussed, and there are various stages kind of in the process. We're going to focus on the SCORE Act. Excuse me, the Student Compensation and Opportunity Through Rights and Endorsements Act. From an industry kind of bigger picture institutional perspective, very similar to the executive order, the SCORE Act incorporates the same or similar provisions that are already included in the NCAA manual and CSC guidance in the House settlement itself. Items like prohibited compensation. It uses the valid business purpose standard that we've already talked about with regard to what is a permissible third-party NIL agreement. And then it also includes permissive restrictions on NIL for deals that are potentially inconsistent with an institution's values, for example. I think the big thing that everyone's kind of on the edge, excuse me, on the edge of their seat about is potential antitrust exemption and preemption of state laws, which is, of course, something that the NCAA and the membership have been asking for several years now. We'll see. I think if you turn on CNN or your channel of choice, there are a lot of representatives that oppose that very thing. So we'll see kind of what happens as we get to the end of whatever that process is going to be. Additionally, there's a lot of nuances related to the Higher Education Act, things like, mandatory student fee disclosures. There's a number of provisions related to that, which we won't dig into. But again, for the most part, it aligns with a lot of what we've been talking about today. From a student athlete perspective, again, it includes a lot of the core guarantees and provisions that Division I already has. For those of you that have been around for a while, things like the old life skills program, this is very similar to that list. Academic and career support, medical, health and safety guarantees and safeguards, scholarship protection. Again, for those of you that are in Power 4, this is like, we already do this, we know, but just making that, broadening that for all of Division I. Now, how the Act defines the institution that these would apply to is if any coach makes $250,000 in base salary per year, these things would kick in. So to the extent of, is it just Power 4? Probably not, but it does kind of, in a way, kind of rename, the autonomy group, just from a federal perspective. Modifies and establishes agent regulations, mandatory disclosures, again, very similar to what we've seen, minimum sport sponsorship, 16. So there isn't a ton that would be completely groundbreaking in terms of, substance, but it, the fact that this would be federal does change, particularly enforcement, right? So I think that's kind of the overarching, who's going to enforce this? The question is always underlying, like, well, how much trouble am I going to be in, right? So if it's federal law and state law and the NCAA and CSC and whoever else comes along, I think on one end, everybody has different rules. And on, the other end of the spectrum, there are no rules. But to Jason's point, I think the key that I would just have personally is whatever you're going to do, make sure it is documented and defensible. And there is some sort of methodology, strategy, some real intention behind whatever it is, as opposed to letting whoever on campus just kind of throw their hands up. Well, no one's coming for me. We don't know what the rules are, so we're going to do whatever. I'm kind of getting a COVID feeling that we're going to get, changing rules, guidance week in and week out. And then you certainly don't want to be the institution that 3 years, after all of this, gets hit for something that happened in, month 1 or 2. So that would be my spiel as it relates to kind of where we're at right now. And the last couple minutes, I'll turn it back over to, oh, just kidding. Okay, you know what? This is it. I forgot we had this slide. Never-ending litigation. I'm not going to go through all of these cases because we don't have time. But you still have 20 active lawsuits related to NCAA eligibility rules. I think that list just gets longer. Still have Title IX cases and NIL cases. As Jason mentioned earlier, I think it's really interesting that as some institutions have kind of, for lack of a better term, kind of had it with, whether it's enforcement within, NCAA, NCAA world, like we're going to court, and instead of tampering, we're making a claim for tortious interference, which we certainly haven't seen before. So a lot more to come on this. Again, the stakes are really high, and there's a lot of confusion. There's a very long list of all of this, which we are happy to follow up with afterwards if anybody really wants to dig into any of these particular cases or issues. Okay. Wrap us up, Jason.
Yep. Sorry we're over. We appreciate everyone's time today. Just real briefly, permissible betting on pro sports. There's a bylaw that would allow, or a proposal that would allow for wagering to take place on professional sports. The proposal will be approved and adopted by Division II and Division III if approved by Division I. I think, just real quick, this is an emphasis for the president of the NCAA, Charlie Baker. Sports betting is. We have seen this with enforcement staff being an emphasis, them having more gambling cases than perhaps even other recruiting cases. And as a result, even though it may be legal in your state, it's important to understand what the policy is, to have education, to have that documentation of education with your athletes, because it's betting on college sports at any level will continue to be prohibited by the NCAA. So that being said, I want to thank you again for joining us. We hope the information was helpful. As a reminder, this program has been approved for legal education hours. To report your hours on the click on the continuing education sign-in link at the top of your screen. A certificate of attendance, including a course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. This concludes our webinar. Thank you again for your attendance.